So we really focus our area of practice on everything from doing a will to helping someone after a loved one passes away in distributing assets to beneficiaries, to guardianship proceedings, protecting assets, working with clients with their property, a lot as well.
Fantastic. That's a lot of different avenues that you're in every day. So it must be
Yeah,
nice to have a lot of different things to work on
it
every
is.
day. Now, specifically today, we're going to talk about trusts and how they relate to real estate and some of the New York State specific things that people need to be thinking about when it comes to estate planning for their properties. So the first question we have is, what is a trust and who needs one?
Sure. So a trust is a contract. It's a contract between an individual called a grantor and a trustee. And the purpose of a trust really depends on what type of trust it is. So there's a number of different types of trusts that individuals can create. Most of the time, we're talking about either a revocable trust or an irrevocable trust. The primary purpose of most revocable trusts is to avoid a process called probate upon an individual's passing. So it's a way for an individual such as yourself to manage your assets for your benefit during your lifetime and then allow for ease of distribution of those assets to beneficiaries after you pass away. So it avoids having to go to court to probate someone's will. It allows for a more complex distribution structure than a beneficiary designation form might. For real estate in particular, it allows property to be distributed to individuals upon someone's passing or to be sold and money to then be distributed upon someone's passing without having to go to court. Many clients will come to me and say, well, I don't need a trust. I just have beneficiaries on everything. And
Mhm.
until very recently, you couldn't do that with real property. So if you owned a home in New York and you, for example, owned it joint husband and wife with your spouse, upon your and your spouse's passing, whoever passes away second, that asset is in their name alone, requiring
Right.
probate. But trusts are really kind of the gold standard for transferring property, transferring assets without having to go to court
Okay.
upon passing. So that's revocable trusts. And irrevocable trusts have a number of different purposes. In my practice, we do irrevocable trusts called Medicaid asset protection trusts very frequently, which the purpose is to protect assets from the cost of long-term care. And those trusts are very unique because they still provide a lot of benefits to the creator of the trust. While it's irrevocable and the person creating the trust can't control the assets as easily, there's still a lot of flexibility within that type of trust. Other irrevocable trusts might be for creditor protection purposes or to lower the size of someone's estate based on estate taxes in New York.
Mhm.
Um, so that's sort of what a trust is.
Okay.
But in a basic level, it's a contract.
Right. It's essentially just a more secure way of transferring your assets upon your
Correct.
passing. Right. Okay.
Yeah.
I think a lot of people think of trusts as, I'm going to put a bunch of money in and leave it to my kids versus
Yep.
what else it can do for you. So,
And I really blame the movies for that
yes.
because it's so funny. Clients will come in and they'll be like, well, I don't need a trust. Like, I'm not a millionaire. I'm not a
Right.
billionaire. Trusts are for people that are really rich. And that's not really what the ultimate purpose of these types of trusts are. It's really to ensure that the client remains in the driver's seat and the money that they have worked hard to generate is being used for them and then
Right.
going to the people they want without red tape.
Right.
So it's
Because the
really
probate
helpful for,
process is not fun for anybody.
no,
So,
it's
yeah.
not. It's not the worst thing, there's
Right.
nothing wrong with probate. It's there for a reason, but if it can be avoided, it can really help ensure certain things and give families peace of mind
Yeah.
as
It can
well.
really save everybody just time and money at the end of the day.
Absolutely.
So,
Yes.
that is a super helpful explanation on that. So when does a revocable trust make sense for a primary residence in New York, and when might it be overkill? And if someone has a second home, like when does that make sense to do that as well?
Sure.
Versus an
So,
LLC specifically is also.
okay. So I'll go to that point first. So LLCs in real estate are typically used for business properties, like if you're renting your property, if it is a commercial property, if it has businesses or your own business
Mhm.
within that property. Sometimes a second home, like a vacation home, might be put in an LLC for certain purposes, or if it's rented a portion of the year. And that can sometimes help or it does help. The primary purpose of an LLC or any corporate entity is to provide liability, essentially
Mhm.
protection, and ensure that someone's personal assets are not exposed to their business property as easily as if they just had it all commingled in their personal name. So LLC interests or stocks, corporations can be owned by trusts. So a lot of individuals who have business entities might also put those business entities' ownership into a revocable trust, again, to avoid probate.
Mhm.
When does it make sense to use a revocable trust with a primary residence? Almost always when you're looking to avoid probate. Now, in some
Mhm.
situations, it may be less of a necessity or something that a client might not engage in until they're older. Like, for example, if you own property joint husband and wife, and
Mhm.
one spouse passes away, it will go automatically to the surviving spouse. So there's no reason to go to court and probate a will at that point. But then when it's in someone's name alone, having it in a revocable trust can be very beneficial.
Right.
When you have multiple properties, especially if they're outside of the state of New York, having a revocable trust becomes instrumental. Because let's say I own a property in New York and I have a vacation home in Florida. If
Mhm.
those assets are in my name alone when I pass away, I have to first have my will probated in New York, the state that is my primary residence. And once that happens, an ancillary probate proceeding has to happen in Florida in
Oh,
order for that property to then be marshaled into the estate. So you're kind of duplicating work, and sometimes
right.
it can be in triplicate or four different ancillary proceedings need to be done if someone
Oh,
has property in a number of different states. So the revocable trust sort of brings it all under one bubble, one bucket, and
right.
makes it much easier for the family to sell property. You don't have a waiting period before things need to be sold. You're not relying on the court. And you're also ensuring that people that you might not want to know about your assets are not provided with notice. A probate proceeding requires that certain individuals get notice and provided a copy of that will. So, for example, let's say you're estranged from one of your children. Even if your will says you leave nothing to that child, if your will has to be probated, they are a necessary party to that proceeding, meaning
Mhm.
you're opening the door for them to potentially contest the will or make a big deal or create an issue or cause additional legal fees to have to be paid out because they're questioning certain situations.
Right.
So there's a level of privacy to those trusts as well.
As much as we want to think everyone's going to behave logically in these situations, they often
Money
don't.
does funny things to
So,
people.
yes, exactly. So when it comes to co-ops, which is a super fun, uniquely New York thing,
Yep.
um, we're talking about shares as opposed to real property. So, what do people need to know about that when it comes to trusts and probate and all of those things?
So co-ops, like you said, are a very interesting, um, I guess, silo of ownership of property in New York. And you're right, you don't actually have a deed to your property. You own stock or shares of stock in a corporation, and you have a lease with them. And while it may feel like it's you own that stock, you are very much so handcuffed to the corporation as to what you can and cannot do, who you can and cannot transfer your property to, and what their requirements are for any sort of transfer. So really throughout the state of New York, co-ops run the gamut in terms of allowing revocable or irrevocable trusts or not, and what procedures they may have or not have in place for how to transfer the stock into
Mhm.
a trust. And I've sort of worked with all of it. I've had situations where a client has wanted to move their home into a revocable or irrevocable trust, their co-op, and the co-op board has said yes. They have very clear procedures on how to do that. The co-op attorney has done it before. They review the trust. They may have language they want to put into the trust. They have additional documents, and a closing typically occurs. And then there's some co-ops that either do not allow any transfers to trust, or they do, but they don't have as clear procedures in place. So it's a lot of back and forth negotiation, explaining what a trust is and what the purpose is in order to get that completed. But because of that, it's a lot more costly, and it's a slower process to get your co-op typically transferred into a trust than just having a deed transfer. So that's one big difference. There's also a lot of very minute details that go into it. One that clients are typically surprised to know and can be very complicated is how the stock certificate indicates ownership for a husband and wife is very important depending on the year that they purchased the co-op. So, good example. I had a client come see me earlier this week, and the spouse, the wife, is still alive, but the husband passed away a few years ago. And they purchased their co-op in 1988. And on the stock certificate, it just says, let's call them John Doe and Jane Doe. So it says just their two names. Now, today, we would look at that and say, okay, if they were married at the time they bought this co-op, that means that they own it by something called tenants by the entirety. There's a presumption that when you purchase property with a spouse, you want it to pass to that spouse upon your passing. But interestingly, in New York, before I believe 1993, the year was, don't quote me on it, but there's a year in the early 90s where essentially any co-op ownership before that date, if it did not specifically state that the husband and wife owned it, joint with rights of survivorship or joint tenants by the entirety, it was presumed that they each owned a 50% share of the co-op. So what we see a lot of times is clients will come to us, their spouse has predeceased them, they assume the co-op is now 100% in their name, but because they bought it before this law change, it's not. And we have to now first probate someone's will and do an estate proceeding to get that co-op to the spouse before we can do any sort of trust transfer. So it's really important to know when you bought your co-op, how it was purchased, and if both husband and wife are still alive, have it retitled essentially so that it's tenants with rights of survivorship or tenants by the entirety, if that's the goal. So that's something that most clients are unaware of, or co-op owners are unaware of. The other thing is that if you have a mortgage on your co-op and you want to transfer it into the trust, you need to specifically get the co-op, the mortgage company's approval to do that, because the mortgage company with a co-op holds the original stock certificate. When you have real property and you're transferring it into a trust, under a law called the Garden-St. Germain Act, there's certain types of transfers that you can do without triggering a due on sale clause, and you're able to just continue to pay your mortgage without changing anything. But with a co-op, in order for them to move the co-op into a trust, you need to surrender the original stock certificate, and the co-op board cancels it, and then they issue a new stock certificate. But if there's a mortgage on the co-op, you don't have the original stock certificate to give back. You need to get the mortgage company to agree to the transfer as well. So it can become a pretty complicated process. A lot of times it's beneficial, especially if the co-op's not going to be sold. There's a lot of beneficiaries who are going to be receiving the property. If the client's looking to engage in Medicaid planning or long-term care planning, moving that co-op into the trust is important. And some co-ops are very high in worth. You know, you could have a co-op that's worth $150,000, or you could have a co-op in New York City that's worth $3 million.
Right.
So it really, it can be a very important purpose to move into a trust.
Right. Just to add to the fun complications of
I
the
know.
world of co-ops, which is
Yeah.
always fun
Not
to help
my
people try to
favorite type of
navigate.
ownership
I
of
don't think
property.
it's anybody's favorite, but it's
I'm sure you see
that's
it
a
though.
whole
There's
nother
not a
call as
lot of
well.
options sometimes, you know. A
Yeah,
lot of property is co-op
right.
in New York.
That's like I said, a whole nother call to talk about co-ops and all the fun that goes into those. Um, so are there any specific estate tax issues that people need to think about when it comes to trusts and planning with their property?
Sure. So New York does have a New York State estate tax. And the New York estate tax exemption for the year 2025 is $7.16 million, meaning that if the size of your estate is over $7.16 million at the time you pass away, you have a taxable estate in the state of New York. New York's estate tax is quite onerous in that
Mhm.
if you go over that exemption amount by 5%, so if the value of your estate is 5% more than 7.16 million, your estate is not only taxed on the overage above the exemption, but every dollar back to dollar one is taxed. It's a
Mhm.
sliding scale tax rate with the top rate being 16%. So it can be a very hefty tax.
Yeah.
And we're seeing that, you know, individuals in New York, especially Westchester County, the surrounding counties, are getting closer to that $7.16 million fairly easily, you know, without
Right.
even thinking about it. You may be close to that with the size of your property, you know, the value of your home, life insurance comes into it,
Mhm.
and retirement monies as well. So doing a calculation of what your gross estate is very important in New York. Now, properties outside of the state of New York, like if you own a property in California and you own a property in Florida, those real property ownership interests do not are not included in your New York
Okay.
estate, as long as you're a New York resident. So it can be lower depending on where you own property. And there's also a lot of unique planning that can be done, especially between a husband and wife, in order to benefit to the extent possible from the exemption. There's also a federal estate and gift tax exemption. Right now, it's around $13 million, and next year it's going to increase to $15 million per person. A big difference between the federal exemption and the New
Mhm.
York exemption is a concept called portability. So if you're a married individual, and let's say, God forbid, I were to pass away, on the federal side, I can leave all my money to my spouse, and my spouse can take my unused federal exemption. So if I haven't made any gifts during life and I have $13 million of exemption, my spouse can port over to him $13 million of exemption, which means that he, at the time he passes away or during his life, could presumably gift $26 million free of taxes.
Mhm.
In New York, that $7.16 million exemption is not portable between spouses. So
Okay.
if you don't use it, you lose it. And if you give money to your spouse, you're not using any of it because of something called the unlimited marital deduction. So
Mhm.
in New York, it's really important for couples who have a taxable estate to do appropriate New York tax planning, which typically includes splitting assets between the two spouses and creating some sort of trust for a surviving spouse's benefit, such as a disclaimer trust, a credit shelter trust, um, in order to ensure that both exemptions are used to the extent possible. Other techniques, including trusts, is to transfer assets out of someone's name during their life to lower the size of your estate.
Mhm.
And oftentimes, trusts are used for that purpose, either because the money that's being gifted might be going to young individuals, such as grandchildren. It may be going to other children as well. And perhaps the individual gifting assets wants to ensure there's creditor protection, protection against future divorce or separation of a child from their spouse, and ensuring that the money that is being gifted is going to the people the grantor, the creator of the trust, intended.
Mhm.
So trusts are used as a way to decrease the size of someone's estate. And there's a lot of different techniques depending on each person's situation. A lot of planning is so specific to the individual. So it really depends on their facts and circumstances and their goals.
Right, exactly. So what is the biggest myth that you see in when people talk about trying to avoid probate in New York?
So the biggest myth that I see with avoiding probate is that having a will avoids probate. People often say, well, I have a will, so no one has to go to court. My will says what I need, where my money goes, who my executor is. But a will is just a declaration of what you want. And in order for that will to become valid, it has to be authenticated by the court. And the reason for this is it's a document that indicates someone's wishes, but those wishes are not to be executed on until the person passes away. So at that point, no one can go and ask the individual who prepared the will if this is their will, if this is what they want, because they're deceased.
They're not there.
So probate is the process of having that will authenticated and ensuring that all necessary parties receive a copy of it. So if you have assets in your name alone, without named beneficiaries, without joint owners, that is a probate asset. And the moment you pass away, that account is frozen. No one can touch that money until someone becomes appointed as the executor of your will and gets letters testamentary, which is what the court provides to an executor that's appointed.
Okay.
So if you go to the bank with your, or a relative goes to the bank with your will and says, I'm the executor, please give me access to this account, they're going to say, that's great. I need letters testamentary. You need to go get this will authenticated.
Okay. That makes a lot of sense, and definitely something that I think people don't quite understand about that process.
Yep.
So the next one would be, what's the most common mistake you see families make with a home after a loved one passes, and how do they fix it?
So one thing that I often see is relatives, and depending on what is going on with that property, I usually see this if other relatives are still living in the property, is they might think that the property can just stay in a trust. You know, let's say mom and dad moved a property into an irrevocable Medicaid trust, and now mom and dad have both passed away. Technically, upon their passing, that trust might terminate depending on the terms. And it's important that the trustees actually distribute the assets to the beneficiaries, whether that's by deed, in kind, if the property isn't being sold, or if the property is being sold, by selling it and then distributing the money. So sometimes I'll see properties continue to stay in trust for a significant period of time when they really shouldn't. And that can be detrimental because once an individual passes away, usually that property now has, you know, standard taxes for the property. There's no exemptions anymore. So if mom and dad were getting a star exemption, a veteran's exemption, some relief from property taxes,
the senior star, like all of those things that they can,
that terminates upon their passing. But if the tax department, you know, the assessor's office is not advised of the person's passing, they will continue to get the exemption until they are advised. And then they're going to request a lot of back taxes for everything that's due. So sometimes that comes as to a surprise to individuals. And also, you know, depending on the type of trust, it may be beneficial to sell property at the time the person passes away because of capital gain taxes. So especially for revocable trusts, or if someone owns property and it's a probate asset when they pass away, assets that are in someone's estate at the time they pass typically get what's called a step up in basis to date of death value. So let's say you bought property at $100,000 a number of years ago, and now that property has is now worth $500,000. If you hold on to the property until you pass away, either in a revocable trust, an irrevocable Medicaid trust, or your name alone, at the date of death, that property gets stepped up to date of death value. meaning that the basis in the property for capital gain tax purposes is whatever the property is worth on that person's date of death. So if the family goes ahead and sells it after the person dies for $500,000 and it was worth $500,000 when they pass away, there's no capital gain tax. But if they continue to hold on to that property and it continues to appreciate, there could be a capital gain tax on the difference. So sometimes that is important to look at. And also, it's important for people to know that, because sometimes clients will say, well, let me just gift my house to my kids. That avoids probate. That ensures they get it when they pass away. I don't need a trust. I'm just going to deed the property to them. That's the cheapest. And while it is, if that property is deeded during life, you're not getting that step up basis.
Right.
Getting something called carryover basis, where that child is now inheriting or receiving that property at mom or dad's original basis, $100,000, for example. So if they turn around and sell it after their parents pass away for $500,000, they're going to have a $400,000 capital gain tax.
Right. And while there's limits on that, it's complicated. And
correct.
This even applies with spouses. I know that there's like a time limit that a surviving spouse has to sell a property after their spouse is passing, where they are exempt from that.
Where they can still
capital
get
gains
a
tax
personal
as well.
residency exclusion.
Right.
Yeah.
So it's all very like, talk to your attorneys. That's what I'm going to say. Talk to your attorneys, because it's so complicated. Lauren, I learned so much today. Actually, thank you so much. You're super knowledgeable, and I'm really excited to be able to provide this information to people, because it's definitely something that is super important for people to really be thinking about. If there was one thing you could leave with people today to be thinking about, like, this is step one in ensuring your properties are protected, what would that be?
It would be to have your affairs in order. Make sure you have documents that indicate what you would want done if you were to pass away or become incapacitated. So it's really important to have a properly executed, broad power of attorney that might allow for gifting authority as well. If you're looking to avoid probate, ensuring that you have a revocable living trust, and also communicating your wishes to your family and loved ones is probably the most important thing. Where I see the most issues arise within families is when there's been no transfer of information, no communication as to what the loved one wants, what they have, who their advisors are. So having those conversations is so important to ensure that people's goals are met, and that they have documents in place that help document that as well.
Right. Nobody likes to talk about it, but make sure people know where the information is. That's a super important thing, right?
Exactly.
Thank you again. And I really appreciate your time.